So good morning, everybody. I don't know if I need to look at the camera or at the audience because we're very, very excited to finally have a hybrid, so both live and online workshop today after, at least in my case, quite a while now. So we're very, very excited to see familiar and new faces here today, live. And of course, with all the participants online as well as also some of our speakers are going to be online. So welcome everybody to this third workshop of the TRICI-Law project, which is about the role of interpretation of customary international law in practice, interpretation as a tool. As I said, we're very happy to have everybody here. Of course, as with all workshops and conferences nowadays, especially due to Corona, we had some people that were unable to join us. For instance, unfortunately, our keynote speaker, Professor Van Haque, was not feeling very well, so she could not attend or join us online. We wish her a very speedy recovery. And for that, I'll blame Ms. Nina Mileva for that and everything that has gone wrong with this workshop. Because 2 days ago, we had a chat and she said, I said, is there anything else that we need to take care of? No, she said, I have everything under control. I even have a folder with all boxes ticked. The Greek in me made a note to tell her that this is called hubris. And of course, after that, people started calling us and saying that there are problems. Professor Werner here as well had an odyssey trying to join us as well. We managed to arrive and we still haven't even started. But we're very optimistic that we've gone through everything. So just a few things to tell you. As I said, the workshop is part of the TRICI-Law project. For those of you who are not familiar, the TRICI-Law project is a 5-year project. I'm the principal investigator, and in the team there is, of course, Dr. Sotiris Lekas and Ms. Marina Fortuna, and of course, Ms. Nina Mileva, last but not the least, who is the main driving force behind this workshop. So the project is about, as you can figure out also from the title of the workshop, about interpretation of customary international law. And I will now yield the floor to Ms. Mileva, who will tell you a little bit more about the workshop, introduce all the speakers, and that's why I didn't introduce you. That's the role of Ms. Mileva, but thank you again for joining. So, Ms. Mileva, the floor is yours.
Thank you, Panos, and thank you, everyone. Welcome. Thank you for being here. So, as Panos already mentioned, this is a hybrid workshop. For us in the team, this is the first time that we're organizing a hybrid event. And we are very mindful and aware of how difficult it is to both attend and organize events in these COVID times. So I just want to express my deep gratitude for all of our chairs and participants and audience who are here with us both in person and online. In this hybrid workshop, in addition to the people that you see here today, we will have, or we already have, an audience of about 130 online. So I hope that everything goes smoothly, and I hope that we can also interact with the audience online when the time comes for Q&A in each of the panels. So again, welcome and thank you for being here. Since Panos shared the more general mandate of our TRICI-Law project, I will turn to the more specific parts of the content of this particular workshop. So the aim of the workshop today is to discuss the role of interpretation in the practice of customary international law. And in particular, this is illustrated, or this is geared towards two main research questions that guide the workshop. The first question being, what is the role of interpretation in the construction or concretization of customary rules? And the second being, how can interpretation contribute, or how does interpretation contribute to the practice of international law more generally? These two questions correspond each to one panel of discussion, and then within each panel, they will branch out into more specific discussion questions that we will put to our speakers. Now, Concerning the format of the panels and the discussion that will take place in the panels, we opted for something that we called a moderated roundtable discussion. And the idea behind this is that rather than individual presentations, the chair of each panel will put questions to the panelists, one at a time, and then the floor will be given to the panelists to comment on the question and perhaps also comment on other things that they have heard in the course of the discussion or on each other's points. And then the idea behind this was to foster a more interactive discussion so that the panelists can also get inspired and can inform their position by how their colleagues might think on a particular issue. Now, in the preparation for the workshop, our panelists were asked to consider the research questions that were put to them through the lens of interpretation as a tool. And we chose this analytical lens of interpretation as a tool in order to illustrate the dynamic and multifaceted role that interpretation has in the practice of customary international law. So with this, we were hoping to illustrate that interpretation plays various roles in the context of customary rules, and various roles in particular in their continued existence and genesis, and how they're practiced and used in the international legal discourse. Now in panel 1, we will hear contributions from speakers who will look at interpretation more in the inward looking sense. So how does interpretation contribute to the concretization or to the constitution of customary rules? And then in panel 2, we will look at what I called a more outward looking perspective. So how does interpretation contribute to international law more generally? In our first panel, we will have Professor Pauline Westerman as our chair. We're very grateful that she is here. And I will leave to her the task of introducing the speakers more in detail. But suffice it to say at this moment that for our first panel, our speakers are Professor Werner, Professor Adil Haque, who is joining us online from the US, and Başak and Tarik, who are joining us here in person. Now for panel 2, we will have as our chair Mr. Apolline Wouter, who is at the moment in The Hague and was unable to join in person, so he will join us online. And our speakers over there will be Ms. Başak, or Professor Başak, who joins us online, Dr. Robert Knox and Dr. Luisa Soares Pereira, who are here with us in person. And I'm sorry, Dr. Johannes Tanner, who is also here with us in person. I also regret to inform that our fifth speaker of panel 2, Professor Itamar Mann, was unable to join us because of a health emergency, but he sends his best and he hopes to be able to engage with the workshop at a later stage. Now, very few words in the end in terms of housekeeping. As you know, the workshop will be streamed live in the form of a webinar. The hope here is that once the discussion of each panel is finished, we open the Q&A, both to our audience present here and to our audience online. I will have access to the Q&A section of the Zoom, so then I will have an overview of all the questions that are asked, and I will do my best to pose all those questions to our speakers, of course, being mindful of the time and the amount of questions. But in this way, we hope that we will engage our online audience as much as possible. As you will see in your programs, we will have a short break in between for lunch, and then we will continue with panel 2 at 2 o'clock in the afternoon. And then finally, a small point of housekeeping for our participants online. We kindly ask you to remain muted when it is not your turn to speak, just to avoid all sorts of echoes and sound interferences. And then if there is any kind of issue with the sound or the image or anything else that is preventing you from access to the webinar, please notify us in the comment chat. And then one of our administrators will see this and will kind of act on it immediately. So I think with this, I will close this kind of opening preliminary remarks, and I give the floor to our first panel to begin with discussion. Thank you everyone once again for being here.
Well, thank you, Nina, for introducing us. I'm supposed to chair this, and I'm also supposed to introduce the panelists, the speakers of this first panel more elaborately, I think. To start with the remote one, Adil Haque. Hi, there you are again. A very small rectangle, unfortunately, but we see a smiling face and waving hand. So Adil Haque is a professor of law at Rutgers University. And he writes on international criminal law and criminal theory as well. And he's author of a book I haven't read, but it's really titled Law and Morality at War, not in war, but at war. So, and it was published in Oxford University Press by Oxford University Press in 2017. Welcome, Mr. Professor Haque. Well, I will put some questions to you later, but first let me introduce now the neighbor at the left side, someone whom I have known for a long time, never talked about international law. He is a professor of public international law at the Vrije Universiteit in Amsterdam. And he is writing on repetition, and I thought it was very intriguing. And I really look forward to your answers to the questions. Because imitation and repetition and restatements, I really look forward. Next to you is Mrs. Başak Etkin. She's a PhD in Paris in France, and she is focusing on state consent and origin of international obligations, and also sources of international law, such as, of course, customary international law and legal theory. So welcome, Başak. And then next to Başak, we see Tarik de Vries-Zou, who is a PhD at the University of Groningen here, and he is dealing with soft law and the possible roles of interpretation in international law. So we are all in the same subject, but then we can wonder whether we are really in the same subject, and we will try to find out by means of very, very intelligent questions. I think it is not a good idea to have an organizer who is so intelligent that the questions that they're asked are already a source of wonderment and confusion and, stimulating source for reflection in themselves. I try to simplify them, but I cannot simplify them too much. And I had some strict instructions to first tell the overall question and then split the whole thing into the smaller research questions, so to speak. But already the overarching question is a source of it's very intriguing in itself, because as Nina said, what is the role of interpretation as a constructive tool in the determination of the content of customary? What is the role of interpretation in the construction / concretization of customary international law rule? And I think that in the slash already there is some hidden problem, because is it construction or is it concretization? But we just gloss over that and we first start with the first question. And now it seems to me that I'm very glad to see Mr. Haque in a bigger format. And it seemed to me that the only person who was obedient and compliant was Professor Haque, because he did indeed address all these four questions, detailed questions, whereas the others sort of did what I would have done, I think, glossed over them and just talked about the things they wanted to talk about. So I start with you, Professor Haque, by addressing the first question. What is the role of interpretation as a constructive tool in the determination of the content of a customary rule? The floor is yours, Mr. Haque.
Thanks very much, and thanks very much for the invitation. I'm a big fan of TRICI and your work, and so when I received this invitation, I immediately accepted. You were so accommodating to let me zoom in, and I didn't think about the time difference. So if we're interrupted by my 4-year-old, she has very strong views about the persistent objector rule, so she may weigh in later. Interpretation plays a central role in the determination of the content of rule of customary international law. Largely, this is uncontroversial. So at least in part, we're trying to extract the meaning of a set of social facts, in this case, conduct and attitudes. Once we do that, there's a further operation where we go from the meaning of the social facts to the content of a legal rule. And then there's a third stage where we determine or decide whether a particular set of facts falls within the scope of the rule that we've then extracted. In principle, we can talk about any of those three stages as interpretation. Many people think we should focus on the first, so extracting the meaning of a set of social facts. Structurally, this parallels treaty interpretation. And here I'm just building off the excellent work of two friends of TRICI, two junior scholars, Adil Aman and Orpheus Tassinis. I hope I'm not butchering their names too badly. So there are structural parallels between these three processes in treaty interpretation and custom interpretation. Obviously, the main difference is that with treaties, we have text whose meaning we're trying to extract, right? But in other ways, these processes look very similar. Very similar moves are made. We look to the purpose or function of the rule. We look for its contribution to the broader system of international law. We try to avoid absurd results. So in many ways, these processes look very similar in custom and in treaty. There are two very important differences. So in treaty interpretation, the primary object of interpretation is in front of us. We have the text. There might be other things we'd have to go searching for, but the primary object of interpretation is in front of us. With custom, it's not, right? Most of the time, we don't know what all the states in the world are doing or why they're doing it. And as a result, interpretation of custom involves a very large degree of conjecture, right, by courts and scholars. So we offer our interpretation, right? We make an interpretive offer. This is Danae Azaria's term. And then we see if that offer is accepted, right? If our conjecture is refuted or confirmed. Right? And states take on board the interpretations of some courts and some scholars in carrying on their own practice. So that's a very important difference, right? We're not sure what the underlying facts are, what the law determining facts are. The other is that it's a much more iterative and dynamic process. So we offer an interpretation based on partial information, and then states respond and custom actually changes. So if they adopt an interpretation, then custom moves in that direction. And so an interpretation that might not have been correct when it was offered becomes correct when states accept it and carry it forward. So those are two very important differences between the two contexts, and they highlight the central role of uncertainty and dynamism in the interpretation of custom.
Thank you, Professor Haque. So it is correct if I understand you as saying that you are not, one is not interpreting a rule, but a fact.
So I think you can really use the term interpretation for any of the three stages, or indeed all three. So Adil, I think, wants to reserve the term interpretation for the first stage, for the interpretation of social facts, texts, conduct, attitudes, and so on. Yeah. That makes sense. I don't think we should fight too much about the terminology. And one reason why I actually think it would make sense to use the term interpretation to refer to all three is because of this iterative quality, because we're always cycling through all three stages back and forth and then going through them again, right, as interpretive offers are accepted or rejected. So for that reason, I think it also makes sense to talk about the whole cycle as one of interpretation. But again, I don't think we should get hung up on the terminology too much.
Thank you so much. I have, of course, the temptation to probe further, but no, I have to be strict in the time, which is hopeless with me. But Professor Werner, can you give an answer to this first question? Can you single out some elements of your theory in order to answer this first question, the constructive two question?
Yeah. Thanks. I think it's two different things. Can you answer and can you give an answer? So, yeah, it's interesting. The question itself presupposes that there is the thing out there, the rule, and that after the rule is there, there is the interpretation. And as you said, I zoom in from the perspective of repetition, and one of the things that make this possible is to unsettle this order. So you could say in the beginning there was repetition. So the idea that there is a rule first only makes sense if there is a second to follow it, so that the second makes the first, so to speak. So my starting point is that interpretation is something of a restatement. So the rule is restated in relation to a specific situation. It might be a situation that occurred in the past, and it might even be something that will occur or might never occur in the future. I think a good example of this is the Talon manual, where you have all these hypothetical situations of things that might or might not occur. And I choose this term restatement deliberately because it enables me to highlight what Søren Kierkegaard called the dialectics of repetition. And it's so beautiful that I will just quote it. He says, the dialectics of repetition is easy for that what is repeated has been. Otherwise, it could not be repeated. But the fact that it has been makes repetition into something new. Now, this might be too dialectical and philosophical. So in order to illustrate it maybe more concretely, I send in a little sound recording to illustrate the point I wanted to make about repetition and the dialectics. So it's called the sound to music illusion that was developed by Diana Deutsch in 1995.
The sounds as they appear to you are not only different from those that are really present, but they sometimes behave so strangely as to seem quite impossible. But they sometimes behave so strangely, 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 so strangely, so strangely, so strangely, so strangely.
Okay, that's the dialectics of repetition. And I think if we go back to the customary law, I think interpretation is dialectically related to the content of the rule, because it must be presented as pre-existent, otherwise it would not be recognized as interpretation, but as the creation of something new. But at the same time, the whole point is to represent the rule, to make it present again, to present it anew. And later on, I will zoom in a little bit on what this representation, so the presentation, the literal presentation, what that might do, right? Whether you do the format in which you do it, I think makes also a big difference. So to use the examples that Adil also used in his written answers to the question of the question of immunities before the ICC, I think both the court and the African Union presented their arguments as representing a rule already in existence. However, both had to represent it, to present it anew in light of different circumstances, or had to argue why new circumstances didn't matter. So I think if it comes to customary law, narrating history, narrating the identity of the community might be a more important thing than in treaty law, for example. I'll come back to that at the end when we talk about the methods.
Okay, just maybe a first question. So repetition is something different from imitation?
No, I think imitation, so both repetition and imitation breed difference. Because and continuity, it's exactly this dialect.
But there are small variations in both.
Yeah.
Oh, okay. Okay. Well, we have to follow up with Mrs. Etkin. Could you? Do I have to repeat the first question, or I look at the audience? No, everybody has a clear mind still in the morning. Okay.
Thank you. So this first question will sort of allow me to lay the main part of my argument, and I'll sort of build on this with the next questions, because I start off with a famous quote from Heraclitus, and I will not cite it in its original Greek with so many native Greek speakers in the house. As we know it, it says, you cannot step into the same river twice. Of course, the problem is Heraclitus never said this, because this is a misquote by Socrates, and no offense to Socrates, but actually, well, this was never said. The closest fragment of Heraclitus is number 12, it says, and I quote, "As they step into the same rivers, different and still different waters flow upon them." And while the misquote sort of focuses on the disunity in change, or things change all the time, the original fragment number 12 actually says some things stay the same only by changing. So there's this idea of flux, but it's not the destructive flux of, it's not destructive of constancy, but it's actually a necessary condition of constancy. It's the flux that makes us call the river a river. And I think this is exactly the case with customary international law. We cannot adjudicate the exact same customary rule twice. So there's, in times T1 and T2, there's unity because it's the same rule, and I'm air quoting. But there's also diversity and change because the contents of the rule have changed. And I see interpretation as merely a part of this flux. It's one of the things that make change happen in the life of a customary rule. And therefore it is unescapably constructive. And interpretation, I think we touched upon this with Professor Westerman's question to Professor Haque, what Adil Aman mentions. So there can be interpretation of the rule itself independently, in my view, but there can also be interpretation of the two elements with state practice and opinion juris, obviously. But this doesn't, in both cases, interpretation affects the content, because what state practice is, or what states believe customary international law to be, will have an effect on the content. And obviously, if we have passed beyond the two-element stage and we're interpreting the rule itself, then, well, there's no escape in affecting the content. So in my view, interpretation is constitutive and constructive of content. And this is where there might be, I guess we'll get to this in a later question, but this is where it might be a bit different than treaty interpretation, where we could conceive things to be more extractive than constructive of meaning.
Thank you so much. It just reminds me of the previous speaker, because you are talking about this well, the slight changes so that it's never the same rule, but it's only the same rule because of the variation. Is it comparable to what Professor Werner calls this repetition or restatement?
I'd say so.
What you have
I don't want to prejudice what he thinks about.
But you think?
But yes, I think it's a very compatible explanation of the thing. It's just two different approaches to one same phenomenon.
Yeah, what do you think?
Yeah, absolutely, because it's also, I mean, he had hard back to the same Greek author to make this point that this is the only way in which something lives. So either it's primordial, so we don't know, right? So you can have the total new, or there is no movement. There was this critique of Haque and everything. There's no movement there. So it's only because there's movement, there's life. I think that's exactly.
Yeah. It seems to me that you arrive at roughly the same wisdom, which is intriguing in itself.
It makes a boring panel, but
I will invent some propositions. Rely on me. Tarik de Vries, you were the last speaker, but hopefully you can enlighten us on your answer to the question.
Yes, because I did answer it in the abstract, although you said I didn't.
No.
There's your controversy.
Yeah, I'm not the only one to invent controversies. No, I meant, of course, you all answered all the questions, but then you did only in one thing and not dividing into 4 sub-questions.
No, that's true. No, I rephrased the first question. I think that's why. No, I rephrased it because tools have their various and limited uses. So I asked what use custom has for interpretation. And I took kind of this perspective of the archetypal judge who is faced with a dispute between some parties and needs in that connection to identify or interpret customary law. I said that to identify customary law means to test the status of a norm which might apply to the case at hand. And in this sense, identification always assumes that you have an abstract notion of the norm in mind that might apply if it's found to be binding. And to that extent, I would agree with Martin Bos when he says that with customary law, content merges with existence. However, Martin Bos also suggests that because of that, you don't ever need to speak of interpretation when it comes to custom. And I suggest that it's not true, because simply by identifying a norm as customary, you do not haven't resolved all the questions regarding its content. So there may be cases where parties to a case agree that a customary norm exists, but they do not agree about how it applies to the case at hand. But I think that the other panelists took maybe a broader perspective than that of dispute settlement. And they also looked at how states must be the interpreters of customary law themselves. And I think this is a very interesting way to look at it as well. There's the example of August 1998, when the United States sent missiles targeting Al-Qaeda bases in Afghanistan, and the missiles passed through Pakistan airspace. And Pakistan complained to the Security Council of a breach of its sovereignty, but not a breach of the use of force. And this would suggest, I think, that Pakistan interpreted the use of force as not applying to this case, to this situation. If a number of examples of such actions were to be taken that are very similar to each other, perhaps another example of repetition, I'm not sure if I can say that, then it must be of interpretive use to the court again. So we see this kind of cycle again. But what I then wonder about is whether we should say that Pakistan formed opinion juris at that moment, or whether its opinion juris informed its interpretation, or whether its interpretation informed an opinion juris. So I'm wondering where the distinction lies now between interpreting customary law as a state and expressing an opinion juris. So that was it.
Well, these last sentences are really music to my ears. Anyway, but I think I have to be strict, because of course there's this temptation again to go on with the discussion, but I'm already late, running late now. So we have to follow your strict order, Nina. I think you were there in the back, as a sort of strict arbiter. And the second question is, it's a very long one. I have to read it because I cannot memorize it. Can interpretation in the context of customary international law be considered the process through which specific elements of a general customary rule are fleshed out? The second question is, just smuggled in here, what are the boundaries between interpretation and the identification of a new separate customary rule in this regard? So whether it's either interpretation of the old rule or the identification of a new one. So this, I think, you are at liberty to address only the first part or the second part or both. I think we have to go back to you, Professor Haque, in order to solve us and to shed some light on this process, on this relation between identification and interpretation.
Sure. So first, yes, of course. So interpretation of custom is a primary way to flesh out the elements of a customary rule, including their personal and material scope, so who the rule binds and what that agent is supposed to do. And in doing so, again, we make many of the same moves. We think about the purpose of the rule, we think about the place of the rule in a broader system, and we make a lot of presumptions that states are relatively rational, consistent, morally decent, in fleshing out the elements of the rule. And then we put out our interpretive offer and see how states respond, and we see if our charitable presumptions about them turn out to be false. I think the boundary between identification of the specific elements or fleshing out the specific elements and identifying a new rule, I think are difficult to draw. So this example of head of state immunity, I think, is a really good one. So the appeals chamber of the International Criminal Court was trying to decide whether the rule of head of state immunity applies to an international court and to states acting pursuant to an arrest warrant issued by an international court. Now, you could think of that as fleshing out the personal scope of the head of state immunity rule. So who is supposed to respect the immunity of heads of state? Is it states? Is it national courts? Is it international courts? So who falls within the personal scope of the rule? And there, I think the court basically entertained the possibility of kind of a deductive reasoning or inference of a necessary implication. So the argument had been made that if states must respect the immunity of foreign heads of state, international courts must. It's a kind of logical corollary because after all, international courts are created by states. And the appeals chamber said, no, we don't accept that. We don't see a necessary implication there. So what we think you're actually trying to do is identify a new rule. So there's one rule saying national courts must respect the immunity of foreign heads of states. Really what you're trying to do is identify a new rule that international courts must do the same. And we don't see any evidence for that new rule that you are trying to assert. So again, we see kind of similar moves. How far can we push in interpreting the content of a rule before we feel like we're really going so far beyond the purpose of the rule or its function in the system that really we're doing something else, we're identifying a new rule. And I think that boundary is going to be fuzzy, but we trip over that boundary by using the same types of reasoning.
So you were saying it's crossing the boundary in relation to the purpose and of the rule and the function in the system. Which one? Which is the most important criteria? The purpose or the function in the system? I mean, the literally underlying justificatory aim or right. The place in the system?
So I don't know if they're in a relationship of priority. Yeah, I'm not sure if they're in a relationship of priority. I do generally think that in custom that function is more important than purpose, that customary rules are more about sustaining an ongoing international practice than achieving particular outcomes that are kind of discrete, right, in a particular case. It's more about keeping the system as a whole running. So from that perspective, I suppose I would think more about function, but I don't know that they're in any particular priority. I haven't thought about it.
Yeah, thank you. Thank you for enlightening me. Professor Werner, you are next on the list of in this second question.
Okay, well, thanks. Yeah, so you already said the question is complex. I think it's quite intriguing because it assumes a very important thing, namely the idea that customary law is something like an uncodified code of law with separate rules where you can identify this is a rule and this is another one. And I think the whole question about the newness is also interesting because I think it's quite a political move to call something a new rule because you delegitimize certain enterprises. No, you're not really doing custom, you're making a new rule. And since there is this dialectics of repetition, it's always possible to either emphasize the continuity or the change. I think that's what you see happening all the time. A second point I'd like to make in relation to this is that in some instances, in quite important instances, it is indeed something like a system, a codified system. So you find customary law being written down in ILC reports, in the Tallinn manual, in the ICRC database and study, where it is transferred from this amorphous legal conscience of a community into a set of rules with numbers and paragraphs and typography and what have you. So it's represented in a very dual meaning of the sense. It's not only represented as done again, but it's also presented to you, but in a different format. which comes with what linguists have called a paratext. So all these things that present the text to you, page numbers, titles, author name, build-up, etc. So it's with a separate heading. So all of a sudden, these customary rules appear as if they all hang together around the topic. You could have chosen a different topic and it would be a different logic, I think. But it's also neatly separated. And I think only in this context, it makes sense to, and it's even possible to say, this is where a rule ends and this is where the next one begins, because you have numbers. One starts at the end of one and two starts at the beginning of two. I think outside of this context, it's mostly a political move to call something the development of a new rule or the continuation of an old one, because I think the dialectics of restatement is at play here.
Yeah, I saw already, thank you so much. I saw already nodding, Mrs. Adil nodding her head. Again, I think you already answered a little bit this second question in your first, but go ahead and elaborate on it.
I mean, so I've mentioned the river analogy, and I think it would be disingenuous to say that the river analogy to customary international law means that the customary rule becomes unrecognizable and it's still the same rule. So it's not like I'm trying to say that a rule on jurisdictional immunities becomes a law of the sea and it's still the same rule. That's not my point. But I think to answer the question, I'll refer to the Hartian terminology of the core and the penumbra, and where does it become, and when are we making a new rule? Well, beyond the penumbra is where we make the new rule. This is evading the question, because what is the limit to the penumbra? We do not know. I mean, it's not an easy question to answer, but in treaty law, at least we have the text, and it sort of is, it marks the boundaries of where we can go. And yeah, so here the penumbra, beyond the penumbra is a new rule. And I was actually, while preparing for this, rereading my abstract, and there I say that if we look for a new set of practice and the penior juris, that could potentially be the indicators of going beyond the penumbra. And I think I'm wrong. I don't think looking for new proof of this rule means we're necessarily going beyond the penumbra. So I think that doesn't make a lot of sense. And I was wrong once again in my abstract when I said, oh, it's not exactly a Sorites paradox. This thing being, oh, there's a heap of sand. If we take one grain of sand at a time, when does it stop being a heap of sand? I think that's a bit the case. When does it stop being the old rule, and when does it start being a new rule? I think we don't know. I don't think we can put a limit to that, because as changes happening incrementally, the rivers, the waters are changing and changing. And I don't know if people agree that we agree, but Professor Haque, again, I will refer to his comments, because at one point, yes, he says there's no clear boundary, but it's also about the simplicity, independence, and interest of, that vary with context and convention. And I was going to say maybe it depends on how specific we are getting with the rule. So if there's a general rule and we are making it more and more specific, more and more precise, not specific, but more and more precise, if we are getting more and more rid of the penumbra and we are making the core more precise, then I think we can safely say we're handling the same rule. Other than that, I could not say.
And you assume that there is a core?
I mean, I hope. I hope there's a core, but that's a really good and I think very existential question. When can we say we're, because will everybody ever agree on something? I don't know.
Maybe we should hope that everything is a penumbra.
Yeah. That's a blessing and a curse, I think.
Okay, thank you so much.
Yeah.
Mr. De Vries, can you follow up with the second question?
Yeah, again, I did answer it. And
yeah, okay. No one read it except for the panelists, I think, and I and the organizers.
Yes.
So the others.
No, exactly. So the I answered it with the Kapchikova-Nagimova's case, and this is a very interesting case because here is what I would just explain is that the parties agreed that a certain customary norm existed, the rule of state of necessity in the international law of responsibility. And they agreed it existed, and they agreed that it was reflected in Article 33 of the then draft Articles on State Responsibility formulated by the International Law Commission. But they disagreed about how it applied to the case at hand. So as a result, the court interpreted the terms within Article 33. So for instance, as the term peril, it interpreted that term in itself as the ordinary meaning of peril, and in light of the context of the rest of the provision, so it compared with imminent and grave. And then it also referred to the commentary of the International Law Commission. And in doing so, I think it very much it interpreted the rule of state of necessity in a very similar way that it would have done if it was in a treaty. Except, of course, we need to understand that it didn't do so because we cannot say that this Articles on State Responsibility show a common intention to be bound. It is something else, but it can still be used. I understand, though, that there's another scenario. For instance, can we derive from the principle of sovereign equality a right for states to have confidential communications with their counsel in arbitral proceedings? So how do we come from this very general rule to this very specific scenario? And can we derive that from a very general norm, this very particular rule? And I think I agree with Professor Werner that especially in this case, the second question is about where do we draw this boundary between interpreting a general norm and just deducing and generating new norms from that general. And as Mrs. Etkin, I cannot answer it immediately right now. I think it's a very difficult one. But I will say, though, that I do not, I think that the problem also persists in treaty interpretation. So, for instance, in the recent immunities and criminal proceedings, the International Court of Justice admitted that the Vienna Convention on Diplomatic Relations didn't really explain exactly how a diplomatic mission could be recognized as a diplomatic mission under the Vienna Convention. And so it had to borrow most of its reasoning from context, the object and purpose of the treaty, and some state practice. In this sense, it's not always easy to say that simply because there is a text or no text, we can say that we go beyond the treaty, I think, and generate new norms.
Okay, you have the last word, of course. I propose to proceed with the third question. But it seems to me, but I'm a little bit skeptic here because it seems to me that the third question looks very much like the second question. I'm not sure about it, but that's my interpretation of it. Does interpretation play a role in the evolution of customary rules? And can interpretation be considered a tool for evolution in the context of customary rules? And if so, what are the boundaries between evolution and modification in this regard? It seems to me that here we have something like, is it new or is it old or whatever? But maybe I hope that Professor Haque can enlighten us on whether you think it is a separate question, because you answered it separately. So probably you thought that it was a separate question, the third question.
Well, I think I engaged in a bit of repetition. So as I mentioned in my opening remarks, part of the dynamism of customary international law comes from this process of interpreting a partial set of lawmaking facts, of legally relevant facts, offering that interpretation, and then the states take it up in their own practice, then custom evolves. And I should have mentioned, I think Başak indicated this, that states do this themselves. Right? So states kind of look around at what other states are doing, interpret the general practice, adopt their own interpretation, and then act on it. And then the next state sees what that state did, and now they have to interpret the whole practice, including what that last state did. And on that interpretation, go forward. And so the practice keeps changing, right? Because each interpretation takes the practice in a slightly different direction. So in that way, interpretation is central to the evolution of international law. It keeps it alive and keeps it dynamic. With respect to evolution and modification, I think this is difficult. I think that in general, I agree with Başak that usually we expect customary rules to change gradually. And in that context, it's not really clear what modification would mean other than just evolution, right? Gradual change. But there is a possibility, which is the idea of instant custom. So there is the possibility that custom could change all at once through a kind of deliberate act. So, the General Assembly announces a change to customary international law. If you think that customary international law can change in that way, then that would count, I think, as modification. Because then we're not looking at gradual evolution, we're looking at a deliberate act to change customary rules. That's obviously controversial, but I think that would count as modification. And I'll just mention that I hope we get a chance to circle back to some things that Tarik said, because I do think a very, very important part of customary interpretation is its reference to treaties, General Assembly resolutions, ILC conclusions, and so on, and then taking those to determine the content of the rule. I think that's a really important part of the practice. So I hope we circle back to that later.
Okay, thank you. Yeah, we come back to that later, I think. Professor Werner, do you think there is a role for instant custom in your view of repetition? Just a sideline, sort of.
Yeah, well, it's interesting because it cannot exist as such. It must present itself as having existed all along. So it always appears as a form of restatement. Otherwise, it's legislation, treaty making, or unilateral declaration. Custom necessarily is in the form of a restatement. So it has no beginning, right? At some point, I compared the genesis of customary law to waiting for Godot. So Godot will never appear, and customary law has always already been there.
Yeah.
So yeah, I think that it's that dialectics.
I suspect so, yeah. So, but also you probably prepared the answer to this third question yourself, and not before you were distracted by my.
Yes. So I struggled a bit with the terms evolution and modification, but here's what I thought of is that. Yeah, I think partly we already dealt with the relation between interpretation and change and repetition or restatement. And I think, just like human beings keep on living by constant reproduction of their cells, customary law only survive if it's presented anew and anew and anew. And just like with cells in human bodies, there are these slight modifications. And there, I think the term evolution is really interesting because that suggests that interpretation is not only just randomly giving your act of cognition or will, but it's about the adaptation of an organism to an environment, the survival of the fittest, the extinction of the ones that fail to adapt. And that made me think of the interpretation of customary law of the German historical school, who argues that customary law fits in the development of a particular historical society. And what I found even more interesting is that claim that at some point these societies become so complex that the law outgrows its members. So what you need is learned jurists who articulate what the society had as its legal conscience all along. Now it's all discredited, we don't believe in that anymore, but I think in a way they were absolutely spot on if it comes to international law. Where we have, exactly like Adil just set out, we have all these expert bodies telling states, this is what you thought all along about the existence of customary rules, right? And you say, yes, right, now you mention it. We have the customary rule, right? So I think that's not fundamentally different from the learned jurists from Tarik and Wouter. So that's what I wanted to say about this.
Yeah, thank you so much.
Thank you. Yes, I didn't know what the difference was between evolution and modification, so I went and opened up a dictionary and looked at the etymology of these words. And both seem to indicate a type of change. But in evolution, I think there's a purposeful connotation, because the origin of the words means to unroll or to unfold. So it's as if there was a divine plan, a purpose that was already there, that is being revealed. It may or may not be revealed yet, but that's what I think, what I thought it meant. And I think, I mean, Waiting for Godot is one of my favorite plays, and so I really appreciate that reference. And I think it's exactly that. There's no beginning, and it will never come, but it's sort of evolving into this thing that we don't know where it's going, but it's sort of in constant evolution. And modification apparently means a small change that keeps the original character intact. I think this could apply to evolution also, but so where I drew the line is between modification and evolution on one side and interpretation on the other, which was not the purpose of the question, but
yeah.
Because I think, well, interpretation is change necessarily, okay. But interpretation is active. There's an authority figure that may be decisive, as in a court maybe, or the state that is trying to convince the others, but there's an active action happening. Whereas change, modification, evolution, it can happen sort of in vivo. It can happen in real life without somebody deciding to change the rule, without somebody deciding to make the rule evolve. And as I was reading Professor Haque's abstract, I thought, oh, this makes a lot of sense when he says, oh, if we're settling the unsettled, so the penumbra, I'd say, if I may, that's evolution. But if we're resettling the settled, so the core, that's modification. And I think this makes a lot of sense. But also, if I may, I think it's arbitrary. We could have put the limit somewhere else and it could have made sense, but this one makes a lot of sense. So I'm happy to go with that.
Yeah.
Sorry.
Well, they were very good questions, Nina, because it reveals a wonder of an enormous amount of new insights. I have to be strict, Mr. De Vries. You are next. You answered already, probably. So we can see your.
This one I did not answer.
Oh.
So it's fair. Yeah, I thought it was a very difficult one, also because of the terminology and the.
Okay, go.
Okay, because to me, modification reminds me of treaty-law, mostly, and certain parties wanting to abide different rules than the other parties. Well, I was actually thinking of the Nicaragua case of 1986 before the International Court of Justice, where the court suggested that if practice goes not in accordance with the prohibition on the use of force, and yet the state acting so invokes the right to self-defense, an exception to the prohibition, that attitude is supposed to not weaken but strengthen the prohibition. And I was then thinking of the example of the invasion of Afghanistan by the United States in 2001. And here, the United States also invoked the right to self-defense, but you could say that it did so under a novel interpretation of the right to self-defense, in the sense that it suggests that one could exercise the right to self-defense if another state is unwilling or unable to deal with a threat to another state. And so and yet other states were disagreed with his interpretation of the right to self-defense. So what I was thinking is that maybe evolution suggests concordant acts of interpretation by states of the customary rule, whereas the modification would require a novel opinion iuris. So if the United States would have said that we may invade Afghanistan not because of right self-defense, but for some other reason, some other exception, and if other states would agree with that, then that would create a modification of the prohibition on the use of force. So that's kind of what I'm pitching now. I'm not saying that's the correct thing, but I was also thinking of the Texaco v. Libya, 1977. Here, Libya invoked resolutions of the General Assembly, which suggested that it could nationalize its oil industry and compensate or not compensate companies according to its own national law and legislation instead of international law. And the arbitrator of that award, René Jean Dupuy, suggested that, sorry if I pronounced that wrong, suggests that there was an overwhelming support by both developing and developed states for resolutions that suggest that nationalization had to accord with international law, and developing states and the same industrialized states didn't support resolutions that allowed nationalization to occur in accordance with the national law of the state, or the nationalizing state. And then he said that those resolutions that would allow for such were seen by the industrialized state as contra legem, so contrary to positive law at the time. But that means that they would have to, that would be based on an interpretation of the positive law at the time, and that interpretation would then inform their opinion iuris. So I think, again, this is an interesting, perhaps, that opinion iuris and interpretation don't have to be the exact same, but they do have a very close relationship, I think. And that's what I was thinking about with this question.
Thank you so much. Yeah, I haven't read it, so you're right. You did it not. I propose to move on to the fourth and last question. And I just wondered whether after the fourth question we should have a short break. That's why I did this gesture. But now, I mean, the smallest gesture is interpreted as instant custom, just to give me a glass of water, which is also very nice. Thank you so much. Amazing. Amazing. This is, I mean, it just proves it proves that you're on here. No, there is some instant custom for it. Anyway, so I was wondering after our fourth question whether we are allowed to have some coffee, have some coffee, or whether you want me to proceed just like this very strict kind of.
So I would suggest, because after the conclusion of panel 1, we have lunch. So I would just suggest after the fourth question, we give the floor to our in-person and online audience for questions, if there are any, and then we just proceed with a longer lunch break.
You have to wait for coffee unless you do something like this. Then you come to fetch me. That's amazing. Okay, the fourth question. Okay, you have your own drink with you. Yeah, that can also be the case. The fourth question is a little bit more specific in the sense that practical kind of thing. Do we need specialized methods for interpretation of customary international law to capture how interpretation functions in the context of customary rules? So do we need specialized methods? And again, I think, Professor Haque, you were the first to answer this question.
Yeah, so I don't know that we need specialized methods. As I've mentioned, I think we make all of the same moves. We look to purpose, systemic fit. We try to avoid absurdity. I think the real question is the status of those moves. When we do that, are we following a secondary rule of interpretation, which I think is generally how people think of the rule of treaty interpretation? So that would occur at stage 2, where we're trying to derive or infer or construct a rule from an underlying set of social facts. So it's that operation, that legal operation from social fact to legal rule. We could be doing that. It could be at stage 1. we could be doing what a philosopher named Donald Davidson years ago described as charitable interpretation of social behavior. We're just assuming that people, in this case states, are relatively rational, informed, accept basic moral principles when we're just trying to understand their behavior and trying to infer their attitudes and understand the nature of their practice. So it could be at stage 1, or it could be at stage 3. So particularly when we're thinking about adjudication, we could be thinking about a rule of adjudication where a court will say, well, look, we don't have all the information we would like to have about what states do and why they do it, but we have to resolve this case in front of us. So we're going to resolve the case in a way that accords with what we take to be the purpose of the rule, its place in the system, avoid absurdity, and so on, as part of our responsibility as an adjudicator. And if states don't like it, they can, tell us that we got the custom wrong or whatever, but we have to decide this case, and so we're going to do it in a just way. So the status of these methods is, I think, uncertain when it comes to custom. I will just note that we may have just seen our first example of a secondary rule of custom interpretation, maybe not. But so the ILC is finalizing their draft conclusions on use cogents. And one of them says that where it appears that there may be a conflict between a peremptory norm and another rule of international law, the latter is, as far as possible, to be interpreted and applied so as to be consistent with the former. And the commentaries make it clear that that conclusion applies to rules of customary international law as well. So that kind of sounds like a secondary rule, right? So where there is potential conflict between a peremptory norm and a customary rule, interpret the customary rule to avoid that conflict. So again, it's a version or it's a component of systemic integration. And again, its status is, I think, really what is yet to be fully settled.
Thank you so much. Werner, are there specialized methods to interpret these statements?
I took the question quite literally. So the question is, do we need specialized methods to capture how interpretation functions? So I took this to be kind of an empirical question. So what actually goes on when customary law is presented, so knowledge about customary law is presented? And well, one thing which is interesting, I learned this from Amy Talgren, if we enters in the sentence is always interesting to ask who says we, but let's assume we have something like a we here. And then I think it would be very helpful to borrow from social linguistics and sociology of science to see how do these interpretations of customary law actually get accepted as valid knowledge claims. One example I'd like to mention here is the research by Liane Boer, who has studied the use of footnotes to underpin consensus claims, where you can trace where if lawyers claim that there is consensus on the interpretation of a rule, where does this consensus come from? And what turns out to be the case, not surprisingly perhaps, is that the consensus is not at the start, but at the end. So you offer a consensus claim, if the others agree that there is a consensus claim, there is a consensus. And there could be other elements which I think would be really interesting, things like cross-referencing between courts and experts' bodies, where this echo chamber of customary law sinks knowledge and rules into existence. A final example that I would like to mention is something that I studied myself a little bit, is the construction of historical pathways in order to underpin a rule of customary law. And I think the struggle around the immunity issue between the African Union and the International Criminal Court is really interesting here, where you see two stories about customary law. One started in Nuremberg and the other, a bit ironically, starting with the European colonial thinkers. And that's the one that is invoked by the African Union in order to tell a history of immunity. And the other history is told by the ICC. And this, I think, is maybe not unique to customary law, but it is quite prominent in customary law because it has no beginning. So as an author of customary law, you have to make this beginning. And just like any story, the beginning predates what comes next, of course, in the beginning, right? So this is something that could be interesting to study, particularly in relation to customary law.
Yeah, I noticed echo changes of customary international law. I will keep that in mind. Very good. Yeah.
So do we need specialized methods? Our answer is yes. Because, and I think Tarik's summary touches on that, and I think we'll agree very enthusiastically. As in treaty interpretation, there's a text. In custom, we do not have a text to go off of. There's no formal ascertainment of custom, which makes it difficult. As I was saying, even when we're identifying, we prejudice the content. So difference between existence and content is difficult to mark down. And so treaty interpretation and customary law interpretation is different. And if we treat them as the same, there's a legal fiction there. And I have a small problem with legal fictions because it means that we're making up for something that we cannot explain, and that's sort of a defect in our understanding of it. And I think we should, I don't mean that they are not functional or purposeful, but I think we need to scratch where it itches, where the fiction is, so that we can sort of understand it better and hopefully get rid of maybe the fiction and have a real explanation. This means that we should not treat, this is recorded, right? Great. This means that we need separate rules for interpretation of custom. And I think one way to look at this, one way to explain the difference between them is with direction of fit, because in treaty law, world fits word, and in customary international law, words fit world, because we make as if there's no beginning, Godot, custom always existed, so there's a world that has to be translated into words. So I think as the direction of fit is opposite in these two instances, the rules have to take that into account at least.
Okay, you don't think that there is a word-to-world relation in customary law?
Well, once we have put the words on the customary international rule, then it's both ways, maybe. But if we are identifying a custom for the very first time, then there's just a world, and we're trying to put the right words on the world to sort of be able to express it.
I see your point. Yeah, thank you so much. Tarik, yeah.
So I think my answer to this is somewhat informed by my research right now about soft law. Because right now I've been looking at articles 31, 32, the United Convention Law Treaties, and thinking, where does soft law fit into this? So I've been taking very much an approach to the rules of interpretation that asks about what materials can we use in the process of interpretation. And I think that the rules would have to be different with customary law, because we're not trying to interpreting customary law, because we're not trying to unravel what some subjects intended to be bound by at some point in time in the past. Is what also sets customary law apart from unwritten acts. So even though we might say that customary law and unwritten acts are both unwritten, I would say the rules of interpretation still have to differ, because they are different objects. So an act is still an act of trying to become intentionally by being bound by something. So I would say that the interpretive anchor lies somewhere else. And this is the concept I would invoke, that instead of the anchor having to be in a text, which is understood to be the final accord between some parties, which I didn't want to add or detract from, it must lie somewhere else, and it's not informed by what might be the common intention, but something else, and perhaps the words would be the common conviction of what the law is, of what customary law is.
Okay, thank you. So you all agree that there should be specialized methods? I
Yes.
understood it correct. Yeah, we're all in agreement, but no controversy about that. You should be noted. So it is your wish that we just go on immediately with a Q&A and no coffee.
Just saying.
And there are, and I have to remind myself, there are 130 persons watching us. It is terrifying. Anyway, because I only see you. What is your idea? Because I cannot have the chats here. I have no. So you moderate the chatted questions.
So I would suggest first we give the floor to
Yeah.
present members if
First
there are
to the
any questions. And in the meantime, I will check in our Q&A session if anyone posed a question for this panel, and we
Okay,
can go off there.
so that will be a joint share. Panos is the first to raise his hand. I'm not sure whether it's about the content or about.
No, it's a comment about you being the persistent objector and wanting to. But first of all, thank you all very much for the very interesting presentations. I have one question / comment, but I'll before that just to give credit to Adil as well. Thank you very much for mentioning the use cogents report, because indeed it is one of the few times that interpretation of customary international and use cogents has been recognized. I might argue that maybe the report on immunities got there a little bit first, because they had a lot about teleological interpretation of immunities, Wouter's dialectical discussion also in the report. But yeah, I mean, there must be at least a couple of friends of TRICI-Law in the ILC and maybe in the drafting committee. Now, the common theme that was, especially in the first 2, maybe 3, maybe even 4, all the questions was about the change. So what I wanted to ask is whether you think that this is indeed really so different with respect to treaties, essentially, because you mentioned that, yeah, we cannot distinguish between interpretation and modification if we consider interpretation as clarifying with a number and modification being something completely different. But isn't that exactly the same also? Well, not exactly, but partly the same with respect to treaty interpretation. And yes, you have in treaties specific provisions where you have amendment and modification. But the hours when discussing subsequent agreements and subsequent practice, they also discuss about whether treaty can be modified by subsequent practice. They took the easy way out saying, oh, we don't know. But there they also said, well, let's make a presumption that in case of doubt, you're interpreting and you're interpreting intra-various, and maybe there is the possibility of modification. Couldn't the same thing be seen also with respect to customary?
Well, who is to volunteer first? Because you wanted all of the panelists.
Oh, whoever wants it, doesn't, I don't.
So if they are all shy away from it, then you get no answer at all. Unlike, of course, Mr. Professor Haque is there as well. Can you answer the question by Panos?
Yeah, I think so. I like the idea of a presumption that when a state asserts a view about customary international law that they are interpreting, not modifying. And I agree, I'm forgetting now who raised this point, that to say that someone is seeking to modify a rule of custom, it is a way to kind of denigrate their proposal, to cast it as illegitimate. So yeah, so I think there are many structural parallels between treaty interpretation and custom interpretation. And certainly when we get into the area of subsequent practice and the interpretation of a treaty, I think the structural parallels are even stronger. So.
You all agree or what? Yeah.
Yeah, I think there are a lot of parallels, especially given that a lot of customary law is written down as if it is a treaty, so it appears as if it is a treaty with numbers, bolds and titles and authors and what have you. And I also would say, also with the interpretation of treaties, you always, in order to be heard, have to present it as if it was already in the text, because otherwise you're making it up, and who are you to make it up? So that I think that is the same. But I think it's almost like an empirical question, and I didn't do extensive empirical research, but something that I find, at least with this amateur little research that I did, what I found striking is the way in which history enters arguments about customary law. And I think that might be something to dig deeper into. Where do you start to tell the story of a rule of customary law? And that might be different in the context of treaty law.
Want to add something? Tarik,
I concur.
Başak? Yeah, no? Okay.
Yeah. Oh, okay.
Yeah, and the second question was by Kostya.
Yeah, it is a little bit awkward because I can see Adil, but Adil obviously can't see me. But hello. But I have a question to, it is actually inspired by what Professor Werner said, but it is more of a question to everyone. And it is about the internal contradiction in the concept of instant custom, something that Professor Westerman already teased a little bit. So I'm wondering if that's really such a problematic concept, in the sense that, like, using Professor Haque's these 3 stages of interpretation, and we were speaking about the instant custom, we were kind of on the first stage, right? So we're trying to find a way to fit some normative content into the existing world. And the contradiction seems to be in the fact that, okay, custom requires some history, right? As you said, so it must have already been there. But I'm curious if this must have already been there is actually what works differently in the normative world. So what I mean is this: of course, custom has some point of origin. Yeah, and instant custom has a point of origin, like, for instance, now or just yesterday. But the normative logic of the custom is such that even when it appeared just now, works as if it has always been there. And so the normative logic does not work like a time arrow, from the past to the future, but it can also work backwards, right? Yes, it has only appeared now, but we treat it as if it has always been this way. And if we approach it this way, right, so that we kind of the instancy is not in the historicity of the custom, but it is in our constant attempt to conceal the origins. And when we're successful to conceal the origins, then it is custom even when it's instant. So I'm curious to hear whether that makes sense from the perspective of interpretation and also of origin of custom or international.
Is there a specific norm addressee here or a question?
Yeah, it's more for Professor Werner, but I'm also curious to hear
okay.
from the rest as well.
Professor Werner, you are.
Thanks. This is a really intriguing question. It reminds me of Derrida's reading of the American Constitution, where it says, before the Constitution, there was no people of the US, and yet these are the authors of the Constitution.
Yeah.
And it's even more stronger in the case of the United Nations Charter, where we have peoples who start writing the charter and then saying, our governments did this, look. But before the text, there was no such thing, right? So the text created the authors. And I think it's the same. So I'm not saying it's problematic. It's the human condition. That's the only way we can make sense of these things. That's what I'm trying to say. So, and it also reminds me of what Said says, that the difference between a beginning and an origin. The origin is like this mystical thing. And the beginning is a cut in time, but can never exist as such unless you assume Genesis 1 to be true. But if you don't, then it's impossible. So then you always have to link back to what went before in order to recognize something as a beginning. So it's exactly this paradox, which is at all these moments of foundational texts. And I think it's a constant presence in customary.
And would you think it's a legal fiction? Because then probably I can.
Controversy.
No, I would say it's the deep reality of law. The legal fiction
Is the legal fiction
the
is.
legal fiction is in the handbooks. But I think this is the deep reality of
Oh,
international
okay.
law.
Yeah. Agree with that?
I think because instant custom is a bit challenging for me because I'm very invested in this idea of no beginning, no end, and instant custom is trying to insert this moment where whoop, it appeared out of nowhere, the rabbit is out of the hat, and
Beginning. Yeah.
and that sort of I cannot really reconcile that idea with my understanding of custom as something that's all encompassing and having always existed. So while I agree with everything that's been said, I cannot sort of put into words how I would reconcile that because I'm not sure if I can. But doesn't seem to be a problem for you though.
No, that's a good life. No, I think it's only a problem. I think Emily Cadence has written very aptly about customary law, where she says customary law was always this fuzzy thing, where this is just how we do things. But the moment you want to combine that with the idea that law is rules and codes, etc., and if you combine those two, you get all these strange paradoxes. So she said it all went down the drain in the 13th century when the jurists got hand of custom. That's her argument, and I think that's quite intriguing because you have two logics that just don't match, and we want to fit it into this idea that law is this rational system with a beginning. And customary law is just not like that. It's,
I thought that I saw Sotiris.
I just wanted to flesh out this idea of no beginning and no end, because I can't follow it really. Because in practical terms, I understand that with respect, it has an enhancing role to purport or to make the argument that, you know, my normative proposition always existed and always was accepted. But in practical terms, it's not always like that, is it? Like the Zagos Archipelago, the court actually looked if there was a beginning to the rule. Or let's say when we talk about, I don't know, the freedom of the high seas, courts usually tend to go and look, when do we, when was the concept of the EEZ introduced? When was, this right, when did this right arise? I understand this, but I don't understand, is it applicable to custom generally? This is what I don't understand.
Who volunteers to answer this question first? Tarik, do you have an answer to that? Not immediately.
Not a very thorough one.
And we do it with a superficial one.
Yeah. No, I was one thing I've been thinking about is how custom sounds sometimes a bit like a sandbox game. So like Minecraft, kind of. There's never unending time and space, and but you can create different structures within it and then put it down again next week and create something new again. And in this sense, custom in itself is never in question. The existence of custom itself is never in question. It's always a specific norm that is in question, whether it has that been made yet. Is that being made? So yeah, that's what my answer is for now.
Professor Haque, maybe we should profit from the fact that your child hasn't been awake yet.
This is miraculous. I was not expecting this at all.
Are you sure she's all right? Yeah?
Believe me, she's fine. Yeah. So I think there are kind of two cases. So one is where an international court says there may be customary norms in this area, but the specific and concrete norm asserted by one of the parties did not exist at the time the act in question occurred. So that's the timing point. So when did the concrete norm crystallize? Well, not until after whatever act is at issue in the case. So that happens. But then you also see cases where the court will say, well, actually, this more specific rule is a corollary, right? It follows from a more general rule that did exist at the time. And therefore, the specific rule existed too. So I think what's going on there, our courts are basically saying, look, once states commit to one rule, anything that follows logically and necessarily from it is already the law. But where there is room for states to concretize a more specific rule in different ways, then we have to wait. Then we have to wait for that more specific rule to become concrete, and only states can do that concretizing move. So I think we see both of those going on. And I should say, when states themselves are engaged in customary evolution, often what they will say is, well, sure, this specific problem is a new one. It did not arise before. But the rule we are now asserting is based on a more general principle that has existed, right? Sovereign equality, right? Non-intervention, et cetera. So that more general rule already existed. And now we're just announcing a more specific rule to deal with this new problem. But we're not making up something new. It's not instant custom. It's based on a pre-existing but more general custom. So that kind of ascending argument also happens quite a bit.
It's always based on more general. It's never the other way around, that some general rule emerges from a more specific or particular.
So I think it can be done, but right. So then you're kind of going to go up and down. So we have more specific rules. We generalize. We infer a more general principle, and then from the general principle we infer a more specific rule to deal with the case at hand. So I think we see both. And again, that makes sense if you think about legal reasoning in the customary realm as trying to work out the commitments that states have made and give them a logical structure, assuming a level of logical consistency, moral decency, and then putting it to states, right? Do you endorse what we think are your commitments, what you have committed yourself to? Do you endorse those commitments, right? And if they do, then you were right all along, right? And custom really is what you said it was. If they don't endorse that view, if they reject it, then you have to make some revisions elsewhere in your overall interpretive scheme.
Yeah, may I jump in here? So my thing with the no beginning, no end is that when we say, when a court is trying to decide if there's a custom on this, it's observing what's happening. And we do this through practice and opinion juris, and I'm not exactly convinced that this is a great method, but yeah, that's what we have. But so the moment, and when we go back in time to see, oh, did it exist before and before, we're trying to look at the evidence of custom, the formal evidence, because as I was saying, there's no formal ascertainment of custom, but we have formal evidence of custom, which is the two-element system. So what I think when we go back in time and look at is not the norm itself, but its evidence. So for me, because that's how custom we have decided that that's how custom presents itself in tangible terms, because otherwise it's a nebulous thing. So when I say there's no beginning, maybe there's beginning to the evidence, but the norm, it's well, the first evidence is, oh, one state did this, action X. Well, the state did that because that's what they thought the norm was. So I think and this is something Jean d'Aspremont talks about, and yeah, I think I separate the formal evidence from the nebulous norm itself, which is more timeless.
So just to clarify, so is what you're suggesting is not that a norm does not have a starting point, is that our examination does not have it. So in order, there is no cut-off point as to which evidence we need to take into account. Is the one or the other. So the norm has a starting point, the rule, let's say the rule has a starting point, but you need to go infinitely back in time in terms of the evidence that you need to.
I'd say it's the opposite.
Okay.
The rule does not have a beginning, but at some point we need to say, oh, this is the first evidence. And that would be, in quotes, the beginning.
Yeah. So that.
People are actually
but that's why I raised this point. So essentially what I don't want to, so for instance, in the Chinese archipelago, you had the separation of the islands there, which occurred in 65, and the court said, okay, was the prohibition of, of this forcible, essentially, separation in force back in 65, yes or no? The court said, well, we don't know when exactly it began. It certainly began after 45. We know that. And we know that it was in place in 65. So there was a starting point, definitely. This starting point is this in between these 20 years, roughly. But there is a starting point. This is what I'm trying to say. Does it make sense?
I mean, yeah.
Wouter, you wanted to comment on this?
Very briefly, because they get more. Yeah. But I would say the starting point is the claim that it already existed. That's why there was no beginning. So the very first stipulation of rule of customary law has to make an opinion. You were saying, I believe this rule is already in existence. So it's a discursive structure. That's the difference between to decide is to cut in time, and to open your euros is to continue in time.
Yeah.
No, hi. I think the connection there is between when it happens the first time, and this is maybe less a question, more comment. Less when it happens the first time, but when one asserts that it has happened the first time as well. I think that a lot of the time in a lot of the interventions, there was a mentioning of the we. So we offer to states, and then states decide whether they take it up or not, or we acknowledge that even though we didn't know when the starting point was, we knew what it was at 65. But I think the we is kind of key here, as in, and this is when it becomes even more blurred, because the we can be the state who said it was acting lawfully the first time, or thought it was acting lawfully the first time. Or it can be the organ or the person that claims that rule existed at the time. So I guess how I turn my comment into a question is, what do different people in the panel think of the we question?
It's interesting.
Sorry, that was also very badly put.
Who is the we?
Who is we?
Yeah, the interpreters, states, who is we? Yeah, I think it's a very interesting question. Yeah.
It's a wonderful question. It's to quote Beckett again. I said I. So it's but you can also. So one question is, so who is we? But you can also see it happening. So this struggle between the ICC and the European Union is exactly about this.
Yeah.
So not so much who is the we, but what does the we stand for?
Mm-hmm.
Is the we an international community that has to transform because there are sports now and things have all changed, or is there continuity from how long and state immunity still appears? And that's not just about the interpretation of the rule, but it's about the interpretation of what this community is all about. So I think this question, and that's what I tried to say earlier, that in customary law, I think these questions, and they also appear in interpretation of treaty, but I think they're more pertinent in customary law, because it is the law of a community. It is what the community is, right? So who are we? Well, how we deal with each other. That's the we. So the customary law and the we are intrinsically related.
Is there anyone else who wanted to comment on the room question? Because there's another question in the audience as well. No, then I think Andre, you were on the next on the list.
Yes, although I am wondering any online questions, because of course time is getting short.
So we have one online question, so I believe we can accommodate.
Oh, okay, there's no discrimination involved. Yeah, we the audience here.
Yes. Thank you. I'm intrigued by Tarik's example of the missiles over Pakistan going towards Afghanistan. And of course, what you say, either the mixing up or the conflation of issues of interpretation with video euros. Now, of course, we know there is a rule of customary international law prohibiting the use of force by states against other states. So that opinion euros we can establish. But whether or not that particular prohibition would have been violated, issue of application, depends, of course, on how we interpret the use of force. So whether sending missiles into another country would be force to begin with, in principle, we might say yes to that. But whether it would also mean that it's a use of force against Pakistan, because the missiles are simply transiting, you might say, they're simply crossing through the airspace of Pakistan rather than, intending to hit targets in Pakistan. And that kind of goes therefore to the issue that we know there is an opinion euros on the prohibition of the use of force. But then the question becomes, of course, what does its scope of applicability also raise issues in terms of transit of weapons through airspace, for instance? And that's where, of course, you have an interpretation question, precisely what the use of force means in this particular context. So that's, I think, how both get conflated. Now, after this example, as you said, I think, we might also say there is an opinion euros that transiting weapons would not actually constitute a violation of the prohibition, because the prohibition would not be applicable to transiting weapons. So there you see also the repetitive character, I think, of what various speakers have referred to, and the restatement issue, you might say. So I kind of, was just seeing whether that's indeed your interpretation of things.
Yeah, that is very, I think, pretty much what I was considering about the concept. Yeah. Yeah, exactly. The example, by the way, is taken from Olivier Corton's The Law Against War. Yeah.
That was a very short answer. And a very long question, a very short answer. Is there anyone who wants to comment and to add something?
I was thinking about, sorry, I was considering the nuclear weapons advisory opinion about, I don't want to reopen the box again.
Oh yeah, we are full of boxes here. I mean, I have a couple of other boxes in my back of my mind. But I think that there was, did you wave your hand? Oh, okay. Yeah, sorry, I misinterpreted your, yeah.
I think, so the nuclear weapons advisory opinion is just quite disappointing in a way, because the International Court of Justice found that there is no customary prohibition on nuclear weapons. And part of its analysis required it to look at resolutions of the United Nations. And it said that these resolutions did suggest that the prohibition on use of force applied to nuclear weapons. As that was, I think, that was what it suggested the covered interpretation of these General Assembly resolutions was. But that they did not show a conviction that there was a prohibition applying to nuclear weapons as such. So one may imagine, though, that, well, that's too bad if only the General Assembly had reformulated that those resolutions. But if they had done so, probably nuclear power states wouldn't have accepted those resolutions. So, in fact, a declaration of what the law is still also has to meet everybody's acceptance about. So it's always a conviction of what is being bound And in contrast to treaties where it's an intention to be bound to something in the future.
Is there anyone in online who is waiting for answer desperately?
So we received one question online. It is by Adil Reyes, and I will now read the question in full. What weight would you give to the achievement of a legally certain result when interpreting customary norms? In case of doubt between two similarly reasonable interpretations, how hard should we go for the one creating a more legally certain situation?
Okay, that's another Pandora box indeed. Okay, who wants?
It goes beyond custom, no? Is it?
So the question is specific to customary norms, but you may, if you feel the need to comment in a broader sense, that's also all right.
Professor Haque, we are turning to you. Every time we are at the loss, then we look at the screen. Because you're on screen, of course.
Yeah. So as my luck is rapidly running out, so I think this actually is a nice question to return to this question of who are we? So I think that when states are discussing among themselves what exactly is our custom, what is our rule, one very often sees this question of certainty being raised, with some states saying, well, look, we need to be clear about what the boundaries are so everybody knows the rules of the road and we don't end up in conflict because one state thinks something is permissible and another state thinks it's impermissible. So there's a high premium on clarity. I think with courts, they're just trying to settle in general the dispute in front of them. So they only need as much certainty as is required to settle that dispute. Systemic certainty might be desirable too, but maybe it might not have the same weight. And then I think for scholars, it sort of depends what role the scholar is assuming. So very often scholars will just sort of present the possible interpretations and leave it at that. When they go forward and make proposals, then again, I think you'll see certainty a certain weight being placed on certainty, particularly with coordination conventions, coordination customs that are supposed to smooth international interactions and keep states out of conflict. Maybe customs that are more value-oriented, that are more about instantiating moral norms, maybe certainty has less of a premium there, and there's more room for moral judgment at the point of application. So that might be a difference among customary rules.
Thank you. Thank you. Anyone who wants to add something? Yeah, Philippe?
So it's actually really funny because it relates to something I'm writing about now, which I didn't think I would talk about. And it's a bit of a specific answer in that case. It would also depend on what phase of the proceedings it would be at. So if it would be a matter of provisional measures, the International Court of Justice at least has to decide whether the claimed right is a plausible one. And in case of conventional rights, it is seen whether the applicant is given a plausible interpretation of the treaty that would support its claimed right. In contrast, for instance, in the Timor-Leste Australia case, I think it's called seizure and data and seizures, I'm not sure. It's the claimed right was that Timor-Leste had right to confidential communications with its counsel, and the court said this might plausibly be derived from the principle of sovereign equality, which is actually what I mentioned earlier as well. And that would mean that it is a possible interpretation, perhaps, of the principle of sovereign equality, and not necessarily the correct one. And the correct one would have to come later on in proceedings on, for instance, preliminary objections or merits.
Okay, thank you so much. I'm just looking at the audience. Yeah, Panos, for last final
question. Because I know you're looking at me angrily for the coffee.
I hear all the noises of dishes and so on, so that is what's distracting me.
Fair enough. So I'll try and keep it short. So my question goes to, so we said that if we have, let's say, a rule, that it makes sense that we can interpret the rule. And then we also discussed that in the before stage, where we're trying to identify whether rule kind of exists, that interpretation also plays a role there. There I have a question about how you would do it. I mean, the idea is that you're saying you're interpreting state practice, so you're interpreting the elements. But my question there is that, because some of the speakers also mentioned that you look at the purpose, the object and purpose, that kind of thing. But the moment you start using the terms object and purpose of what? Because you can't say the object and purpose of the state practice. You're basically going for the object and purpose of a rule. So my question there is, even at that stage, doesn't the person, the judge, let's say, that is interpreting, have a mental kind of image of presupposed rule based on the state practice and opinion theories that they've identified, and then uses that and does proper interpretation as such? Yeah.
I have some music to my ears now. And just I'm making use of my position. What do you think, Wouter, for instance?
Well, I think, again, it would be important to try to make it concrete. So if you look at some of the few empirical studies of how courts identify customary law, it's hardly ever by looking at state practice and linear juris. So they go to treaties, they go to reports, etc. So yes, they start with a rule. But I think even with practice, I mean, it's almost impossible, I would say, to identify a practice without thinking about a point of that practice. The practice just doesn't appear in its naked form as just what you do, because then how do you identify it? How do you draw the boundaries, what the practice is by practice? So just to identify it already gives it a point or a purpose, if you wish.
So you need a hypothetical rule, kind of a hypothesis on which to work, right?
Of course, yes. But, yeah. It's the Karl Popper example.
But then we have
look and tell. So what should I be looking for? There you go.
Yeah, but then we have the controversy maybe because Professor Haque said that what we interpret is not the meaning of a rule, but the meaning of a fact. So that would be impossible according to Panos, because you have already a rule in the back of your minds before looking or at the facts or at the practices.
Yeah. It's a hermeneutic circle, right?
That is so. That is what we started with, and now, now, what do you say to that, Professor Haque?
So I agree. I think the three stages are iterative. I think you cycle through them, or you go back and forth. So, for example, suppose that you kind of enter stage 3 and you reach an absurd result. Probably you're going to go back to stage 1 or stage 2 and try to figure out where things went wrong. So yeah, I think that's right. I think that as the interpretive process continues, we get a clearer and clearer sense both of content and of purpose and of systemic fit, right? And we keep going back and forth. And again, what allows for this dynamism or for this this flexibility is the fact that we don't have full access to the lawmaking facts, to what states do and why they do it. And so we can always keep going back and forth to try to put together a more coherent picture.
So you would agree that there is no such beginning in social facts?
Well, so metaphysically, supposedly the beginning is the social facts. So those are the lawmaking facts. But epistemically, when we're trying to figure out what the rule is, then we go back and forth. That makes sense.
Okay, now, is there, Panos, do you want to add, do you agree with that? That ontologically we have the facts first, but epistemologically we have the rule first? Would you agree with that?
I mean, ask me in a year. I'm still not entirely convinced about, and this goes to the previous question as well, that because Başak also mentioned the sororities paradox. I'm very fond of that paradox. If you say that the rule exists now, the necessary implication, if you want to use that term, is there must have been a start to that rule. Maybe we cannot figure it out precisely, and that's where I do disagree with Jean just for a moment, because he suggests that every single time when we apply a customary rule, we need to look for state precedent. So I find that, first of all, not having any basis in practice, it doesn't make sense.
But this ties back, I think, to what you said a while ago about the two systems or two logics of the rules and the practices, so to speak. Or not?
I'm tempted to say yes, but I'm not entirely sure what
okay.
you refer to.
You just said that there are two different logics.
Oh,
the
right,
social
right.
practices and the normative realm, and that it is very difficult to reconcile them. I think that is a sort of, well, answer to probably to what Panos just remarked.
Yeah.
Yeah. Oh, yeah. This is the perfect ending then of, I think, a very stimulating discussion. I think thanks to the very intricate and complex questions. I had my doubts when I started, but I think it was a marvelous idea to do this. I hope that you intended to reach what you hoped for. That is a set of coherent answers. That's what Nina's secret wish. She desired for coherent answers, and I said, well, you should not wish for that. Let me thank also for, because I think it is indeed more coherent than I thought. Very strange. I'm always a little bit skeptic about those coherences. They probably break up as you leave the room. Let me thank you, Professor Haque, for joining us, and in such a nice and clear way. You were really present in a physical way, I would say. It's sort of social fact that, I think that it looked as if it was a real factual presence. So thank you for that. Thank you, Tarik, for your answers or repetitions of answers you already gave. Thank you, Başak, Etkin, for your nice metaphors also with rivers. And my head is full of the metaphors now, even more than I came up myself. So thank you for that. And thank you, Professor Werner, for your very intriguing views on the restatements as the beginning of customary law. Thank you, audience, for your very patient and intelligent remarks and questions. And I hope that we have now, it stopped. The noises of the dishes stopped. So presumably there will be some food around the corner. Thank you for the patience, and